Welcome to the deep dive. The idea here is pretty simple. We take complex stuff, court cases, reports, analyses, and pull out the key insights for you.
Yeah, basically saving you the headache of wading through it all yourself.
Exactly. We aim for clarity, maybe some surprising bits, just making sense of tricky topics.
So you feel informed, not overwhelmed.
And today we're diving into a really interesting New Jersey family law appeal. The source is a case analysis focusing on the Appellate Division's rulings in APDP.
Right. This one went through a full trial, 11 days, I think, and then the appeal. So we get a good look at how the higher court reviews these complex divorce rulings.
And our mission, well, it's to figure out what the Appellate Division decided, what stuck, what got overturned, and crucially, why. What does this case tell us about handling finances in NJ divorces, especially when things get messy?
And this case definitely had some messiness. The source really highlights the major complication, substantial financial help from outside the marriage.
From one party's parents, right?
Yeah, AP's parents.
Yeah?
Which, created real challenges for the court when trying to pin down the marital lifestyle and figure out support.
Okay, let's set the scene a bit. The case background. We have AP, the wife, and DP, the husband. They got married September 2015.
And the divorce complaint landed January 2020. So, yeah, about 4 years, 4 months of marriage.
Relatively short, yeah. But they had 3 young kids packed in there. Twins in 2017, then another son in 2018.
Right. Close together.
And financially, during the marriage, AP was mostly a stay-at-home parent, didn't earn much before that either. DP was the breadwinner. His salary went up during the marriage.
Okay, standard enough picture so far. But here's the twist, those contributions from AP's parents. The source calls them substantial.
And they weren't just like birthday checks, it was structural stuff.
Exactly. Her parents had a trust, provided homes for them at way below market rent, just covering taxes and insurance, basically.
Oh.
And they paid for nannies, preschools, swimming lessons, club memberships, even private jet travel for family vacations.
So a very high standard of living, significantly funded externally.
Definitely. And the source even mentions an email where DP acknowledged it.
Yeah.
Said the gifts helped his support cover things and gave them a more comfortable lifestyle.
That's a key admission.
Absolutely. And then, importantly, all that parental support.
Yeah.
It stopped cold once the divorce papers were filed.
Okay. So the financial reality changed dramatically right when the court case started.
Precisely. Which adds another layer of complexity for the judge.
So procedurally, it went through the usual hoops. Temporary support orders, what lawyers call pendente lite support.
Yep. Pendente lite orders, an agreement for DP to get an advance from marital funds for rent, I think. Psychological evaluations for custody.
Disputes over getting info on those family trusts, too.
Oh, yeah. Definitely discovery fights.
Yeah.
And then that long 11-day trial.
Okay. So after the trial, the judge rules on everything. DP appeals 7 things. AP cross appeals 2. A lot of disagreement.
For sure. The big issues up on appeal were custody and parenting time, the trust discovery fight, alimony, child support, how assets were divided, equitable distribution, and legal fees. Who pays?
Right. Let's tackle custody and parenting time first. This is interesting because the Appellate Division actually agreed with the trial judge here.
Yeah, the trial judge ordered joint legal custody, but made AP the primary residential parent, the PPR. DP was the PAR, parent of alternate residence.
And AP got the final say on education decisions.
She did, yeah, though she had to pay for the private school. DP got a specific parenting time schedule, detailed but less than what he wanted.
So DP appealed that, wanted more time, shared decision-making, especially on schooling.
That was his argument, yes.
But the Appellate Division said, nope, trial judge got it right. They affirmed the whole custody and parenting time setup.
And the key reason really comes down to deference. Appellate courts give a lot of weight to the trial judge's feel for the case in custody matters.
Because the trial judge saw the witnesses, heard the testimony firsthand.
Exactly. The Appellate Division found the judge correctly applied the New Jersey custody factors. N.J.S.A 9.2-4. Things like how well the parents cooperate or don't cooperate in this case.
Right. Their inability to cooperate was noted.
Yeah. And the kids' needs, AP's availability as the stay-at-home parent versus DP needing childcare. It all pointed towards the judge's decision being in the kids' best interests. Plus, there was an expert evaluation, Dr. Hagofsky, supporting it.
So the specifics held up too, like AP having final education authority, even the changes to the overnight schedule.
All upheld. The education decision was tied to best interests, with a check she had to consult a parent coordinator. The parenting time tweaks, like removing Sunday overnights based on AP's testimony or changing Monday based on DP's own comments about childcare, all found to be supported by the record. Equal vacation time, too.
Okay, so lesson 1. For custody and parenting time, a well-reasoned trial court decision, backed by evidence and the statutory factors, is tough to overturn on appeal.
Very tough. Deference is powerful there.
All right, what about that discovery fight over the family trusts? DP wanted full access, right?
He did. He wanted to dig into all of them, probably looking for income or assets he could argue should count.
But the trial judge said no, just limited info on disbursements from 2 specific trusts.
Correct. Denied broader discovery, based partly on statements that other trusts weren't funded or weren't set up to benefit AP yet.
And DP argued on appeal that limiting him like that was a mistake.
Yep. But again, the appellate division affirmed the trial judge. No abuse of discretion, they said.
Why did they affirm this one?
It seems largely based on formal statements, certifications from AP's parents and their lawyer.
Ah, the third parties involved.
Right. They certified that AP and the kids had no guaranteed income from these trusts until AP hit 65, and that some trusts DP was interested in were basically empty shells, unfunded. The court felt the judge struck a reasonable balance.
A balance between DP's need for relevant info and the parents' privacy.
Exactly. They didn't want a fishing expedition based on just speculation. The court cited the Tannen case, too.
Tannen v. Tannen, what's the rule there?
Basically, just being a potential beneficiary of a trust down the road doesn't automatically mean you can count that as income for alimony now. And DP's claim it was income for child support. The court called that mere speculation.
So getting deep into third-party trusts in a divorce, you need a really solid, specific reason, not just a hunch.
Pretty much.
Yeah.
Privacy wins out over speculation.
Okay, so custody, parenting time, discovery, all affirmed. But now we get to the money stuff.
Yeah.
Alimony, child support, equitable distribution. And this is where the appellate division said, hold on.
Yeah, this is where the reversals happen. Big ones.
Let's start with alimony. Trial court gave AP limited duration alimony about $2,500 a month for 3 years.
Right. But the absolute killer phrase in the trial judge's decision was this. The judge wrote it was impossible to quantify the marital lifestyle because of all the money from AP's parents.
Impossible. That sounds like a red flag.
Huge red flag. DP jumped on that on appeal, arguing you have to quantify the lifestyle for alimony. You can't just throw up your hands.
And the appellate division agreed.
Emphatically. Reversed and remanded the whole alimony award. Sent it back for a redo.
What was their reasoning? Why is impossible so bad?
Because, as the source details, quantifying the marital lifestyle is fundamental in New Jersey alimony law. It's the touchstone, the starting point. They cited major cases like Cruz and SWVGM that hammer this home. Saying it's impossible is just, contrary to established law, a fundamental error.
Even if it's hard because of the outside money?
Even then, the court basically said, hard or not, you have to do it. The failure to put a number on that lifestyle invalidated the whole alimony calculation.
And that has knock-on effects, right? Like for those Malamose credits.
Absolutely. Those credits, which adjust for temporary support paid during the case, are often linked to the established lifestyle need. If the lifestyle wasn't quantified, the Melamo credits need reevaluating too.
Did they say anything about the length of alimony, the 3 years?
They actually found the duration itself wasn't an error, given the marriage length, but they did tell the trial court, hey, on remand, you need to consider that AP remarried, because remarriage terminates alimony by law in New Jersey.
Ah, okay. So the takeaway is massive. You must quantify the marital lifestyle for alimony in New Jersey. No excuses. Figure it out. Put a number on it.
Exactly. Parties need to bring the evidence, budgets, bank statements, maybe expert analysis to reconstruct that lifestyle, even if it was funded unconventionally.
Okay, next financial piece, child support. The trial court ordered DP to pay $535 a week plus 69% of add-on expenses like medical.
Right, and the judge got there using the child support guidelines for part of it, then adding a supplement because their combined income was high over the guideline threshold.
Yeah.
Used DP's $279K income and imputed about $40K to AP.
DP appealed this too, said it was too high, a windfall.
He did.
And the appellate division reversed this one too.
Yep, reversed and remanded for recalculation.
And why this time? Was the judge's math wrong on the guidelines?
Not exactly. The appellate court said the judge's analysis of the child support factors seemed okay, but the final number was based on the erroneous alimony award.
Ah, it's connected.
Directly connected. Child support calculations depend on the parent's net incomes after alimony is paid or received, since the alimony number was wrong because the lifestyle wasn't quantified.
Then the incomes used for child support were wrong too. Makes sense.
Precisely. So child support has to wait until the lifestyle and alimony are properly figured out on remand, then recalculate.
Shows how these financial awards are like dominoes. One falls, the others follow.
Definitely. You need a solid foundation.
Okay, final financial area. Equitable distribution, dividing the assets. The trial judge ordered DP to pay AP around $64,000 to balance out accounts, plus some other amounts for tax refunds, and split the retirement accounts.
The judge also found both parties used similar amounts of marital cash for lawyers, about $35K each, and said that was basically a wash. Didn't accept AP's claim about needing loan repayment either.
DP appealed this division too.
He did. Argued the calculation wasn't right and he should keep all his retirement.
And the appellate division. Another reversal.
Yes. Reversed and remanded the equitable distribution calculation as well. They found two specific significant errors.
Okay, what were the errors here?
First one was a clear double count. The judge included about $86,000 from certain brokerage accounts in the total pot of marital assets to be divided. Then ordered DP to pay AP roughly half of that total pot as an equalization payment.
Okay.
But, the source explains, AP had already received those specific brokerage funds during the divorce case through a Magliamo adjustment. She got credit for them against temporary expenses.
So she got them once as a credit, and then the judge counted them again in the final division and ordered DP to pay her half of them again.
Exactly. She got them twice, effectively. And DP didn't even have those funds anymore to pay the equalization payment the judge ordered based on them being in the pot. A clear double dip for her. An impossible payment for him.
Ouch, that's a big accounting error. What was the second error?
An omission. The trial judge completely forgot to factor in a $17,125 advance DP had received from marital assets early on. It was court approved for rent arrears, supposed to be accounted for in the end, but it just vanished from the final calculation.
It just dropped. Wow.
So between the double counting and the omission, the whole equitable distribution math was flawed and had to be redone.
Did the appeals court say anything about the retirement accounts or the legal fees paid for marital funds?
They actually affirmed the trial judge on those points. So the retirement account should be split equally, rejecting DP's argument, and they agreed with the judge's handling of the legal fees paid for marital assets. Since both used similar amounts, it balanced out.
Okay, so the huge lesson for equitable distribution is track everything. Every temporary payment, every advance, every credit, meticulously, and make sure it's all accounted for correctly once and only once in the final donation.
Absolutely critical. Otherwise, you end up back in court.
Last issue. Counsel fees. Who pays the lawyers? Trial judge denied fees to both AP and DP.
Right. And predictably, both of them appealed that denial. Each wanted the other to pay their bill.
DP argued AK had family money. AP argued DP acted in bad faith.
That was the gist of it, yeah.
And the appellate division
Affirmed the denial for both. Agreed with the trial judge.
Why no fees for either side?
The reasoning was pretty straightforward. The judge followed the court rules, Rule 5.35c, found no bad faith by either party. It was just rigorous litigation, meaning hard fought, but not improperly fought.
And the money aspect.
Crucially, the judge noted, and the appellate division agreed, that both parties paid their lawyers using marital funds in roughly equal amounts, about $32K for AP, $35K for DP. So they both dipped into the shared pot similarly.
So unless one side acts really badly or there's a huge disparity in ability to pay from separate funds, courts in N.J.A are often hesitant to shift legal fees, especially if marital money was used by both.
That seems to be the takeaway here. The bar is pretty high. Using marital funds for fees often just gets equalized in the end, rather than resulting in a fee award against the other person.
Okay, let's pull it all together. What are the absolute key lessons from APBDP? The main things you need to understand from this deep dive.
Number one, without a doubt, quantify the marital lifestyle for alimony. It's non-negotiable in New Jersey. Saying it's impossible, even with outside money involved, is reversible error. You got to put a number on it.
Number two, meticulous accounting and equitable distribution. Track every single interim financial event, Malamo credits, advances, temporary support adjustments, and make sure they're handled correctly in the final judgment. Avoid double counts, avoid omissions.
Accuracy is paramount there.
Yes.
And number three, while the money stuff got overturned, the affirmances on custody, parenting time, and discovery show that trial judges get significant deference in those areas if their decisions are well supported by the evidence and the law. Build that record at trial.
Right. Makes sense. And the source analysis we used, it offered some practical pointers based on this case.
Yeah, basically reinforcing those lessons. Bring solid, quantifiable financial evidence for lifestyle. Maybe use experts. Keep meticulous records of all interim finances. And if you want discovery from third parties like trusts, have a concrete basis, not just a fishing expedition.
This case really highlights that tension, doesn't it, between a lifestyle funded by outside gifts and the legal system's usual way of calculating support based on earned income and marital assets.
It absolutely does. It pushes the definition of marital lifestyle.
Which leads to our final thought for you to chew on. When a family's lifestyle is heavily cropped up by gifts, how does that square with the legal standard? The law usually aims for sustainable support based on the party's own means after divorce. So what is the marital lifestyle in these gift-heavy situations? And how should courts balance reflecting the life lived during the marriage with what's actually sustainable long-term?
It's a tricky balance, and the law is still evolving there. A really interesting question.
Indeed. Okay, that wraps up our deep dive into APVDP. We hope breaking down these appellate division rulings gave you some real clarity on these complex New Jersey divorce issues.
Thanks for joining us.
We'll be back next time for another deep dive.